All right, good evening, everyone. As the room fills up, I'm going to take a couple of minutes before we really dig in and let everybody get into the room. And as you're coming into the room, I just want you to know a couple of things. On the right-hand side of your screen, you should see um, a chat option, a poll option, and a handouts option. So we're going to talk more about the chat in just a bit. Poll, we've posted up 3 poll questions. If you guys would not mind answering those poll questions, they're really simple, they're very quick. That helps me get a sense of who you all are because we have not yet met, and you're going to get to know me a little bit tonight. But by design, I don't get to see you or talk to you directly. But the poll questions give me a sense of who you are, a little bit about where you're coming from, and that can help me even to direct a little bit of the content more towards who you are. I don't want to assume I know who you are. So my name is David Feakes. I'm the owner and founder of the Parents Estate Planning Law Firm. And again, we're going to get started in just a second. If you can hear me, if you can just click on the chat button and give me a quick thumbs up. There's an emoji. You can use emojis if you need to. Just give me a hi or a yes or good. Some thumbs up. Selena, Paula, Chrissy, thank you so much. Great. You guys can hear me. Hopefully you can see me. Give me a thumbs down if you can't see me. I'm the guy a little bit off to the left of the screen. All right. So again, the room is filling up, and I know that people are going to join us even after we get started. But again, if you have not yet looked at the poll questions, just give it a quick look. Let me know if you've got kids. Let me know how old your kids are. If you've named guardians for your kids, let me know that, yes or no. If you have not, don't worry. We're going to talk about that tonight. That's maybe one of the reasons why you're here. Have you created a will or a trust? Yes or no, or yes, but it's outdated. Not unusual. Again, if you don't have a will or you don't have a trust, don't worry. That's why we're here. We're going to talk about all of that tonight. Okay. Okay. So I do want to get started. For those of you who are here right at the top of the hour, again, my name is David Feakes. I'm the owner and founder of the Parents Estate Planning Law Firm in Acton. And tonight we're talking about essential legal planning to protect the people that you love the most, whoever that is. If it's young kids, if it's adult kids, if it's not kids at all, if you don't have kids and you are taking care of nieces or nephews or whoever it is. We're going to talk about the legal planning that you need to have in place to make sure that the people you care about and want to take care of are going to be taken care of by you, and that nothing will be left to chance, nothing will proceed under a default plan. What I want you to walk away with tonight, and what I promise you you will walk away with tonight, is a very clear idea of, number one, where you are right now. It's really important for you to know where you are right now. That helps you to get really clear about where you want to be instead. So my job tonight is to help you get clear on where you are right now. Now, as we talk about where you are right now, and we talk about some options, if the default plan is the plan that's currently in place for you or for your family, you're probably going to start to get clear on where you want to be instead. And some of you may have already given a great deal of thought to where you want to be instead. So I want you to walk away from this tonight knowing where you are right now, having a clear idea of where you want to be instead. And I want you to walk away with some clear steps about how you can move from where you are right now to where you want to be. So you're going to walk away tonight with 9 steps that you can take to make sure that your kids are protected, that your money is protected, that your legacy is protected if something happens to you. Now, before we get started, I want to do a little housekeeping. We're going to be together for about 45 minutes of content. I'm going to share with you as much as I can in that 45 minutes. I want to save some time at the end for some Q&A. If you have questions, you can drop those questions into the chat. So you can post your questions into the chat, and at the end, I'm going to go back and I'm going to pick up those questions and we're going to answer them. And I'll stay on the webinar for as long as it takes to answer your questions. You do not need to wait to the end to ask your question. You can ask it anywhere along the way. Just drop it into the chat. It may be that if you drop a question in early, I may answer your question along the way. And if so, great. But if not, again, we'll go back to those questions at the end. So just use the chat function to ask your questions. You'll want to be on the webinar all the way to the end. Here's why. I'm going to share some resources with you, excuse me, at the end. And I'm going to show you the steps you can take to start to implement everything that you're learning tonight. Because if you learn, but you don't do, where's it going to get you? So I want to give you the steps that you can use to implement, and I want to give you a clear plan of action that you can take even after tonight. So stick with me all the way through to the end. I promise you it's going to be time well spent. Last bit of housekeeping is that this is an educational workshop. So I'm not providing you legal advice tonight. We are not creating an attorney-client relationship tonight. So nothing I'm talking about tonight constitutes legal advice. It's educational. It's going to be educational for you. But I'm not trying to solve your particular problem tonight, and I can't do that because we have not yet met. Any references I make to state laws are references to Massachusetts law. Our firm is located in Massachusetts. The attorneys in our firm are admitted in Massachusetts. And so any references I make to law or the law are going to be references to Massachusetts law. So as I said before, my goal for you is to learn how to protect the people you love the most. And again, you do that by getting really clear about where you are right now and where you want to be. And my job is to supply you the map for how you get from where you are to where you want to be. So you walk away from this knowing how to create a bulletproof, comprehensive, rock solid plan for your family, so that if anything ever happens to you, or if you're married, if anything ever happens to you and your spouse, your kids, if you've got young kids, will be protected. Even if you have adult kids, that they'll be well taken care of, no matter what. I just want to glance back at the poll questions one more time. It looks like most of you have minor children. Great. That really helps me to know that. It may help you to know that a large part of what we do in our firm is focused on parents with young kids. And that will be a good piece of my focus tonight as well. So let me tell you a little bit more about who I am and why do I do what I do. So as I said, I'm the owner and founder of the Parents Estate Planning Law Firm in Acton. Why do I do what I do? Well, the vision that I have for our firm, the reason I get out of bed every morning and go to work, is to ensure that every child has the comfort of knowing that their parents cared enough about them to create a plan for them, a plan to protect them, even if mom and dad aren't there in the future. And as I said, that's what gets me out of bed every morning. And the reason why that's important to me is, number one, I didn't always feel that way as a child myself. So that provides a little extra motivation for me to make sure that kids feel protected, because I didn't always feel protected when I was a child. And number two, I have children. My kids are adults now, but I remember when they were young, and a lot of the things that we'll talk about tonight are things that I had to figure out for my own kids, for my own family. And so lucky you all get the benefit of learning everything that I've learned and developed along the way to protect my own family. So that's why I do what I do. I love what I do. I love helping our clients. I love educating the public. It's why we do these webinars. It gives me great satisfaction. And one of the greatest things about helping families is knowing that when they walk into our office, they are anxious, they are scared, they are fearful because they don't know what's going to happen. They don't know what's going to happen in the future. They don't know what's going to happen to their kids. They don't know what's going to happen to their assets. And we are able to take them by the hand and show them how to create a great plan so that they can walk away from their experience with us now with that anxiety relieved, with that fear dissipated. They know they've got a great plan. They know what's going to happen in the future. They know who's going to take care of their kids. They know what's going to happen with their money, and they know it's all going to happen the way they want it to happen. And every time a client shares a story like that with me, every time that a client shares a story like Deb and Gary have shared with me, it keeps us going. It keeps everybody on our team going. And I want to share those things with you tonight. So here's what we're going to talk about. We're going to talk about, number one, protecting yourself, really about how to create a plan for incapacity. And I think certainly, given what we've been going through for the last year and a half, what we're still going through right now, protecting yourself, I think, is a really important piece. And it affects everybody. If you're an adult, you've got to be concerned about protecting yourself if you get sick and you need someone to make decisions for you. So we're going to talk about that. We're going to talk about protecting your minor children. So if you've got young kids, I'm going to let you know everything you need to know and think about to make sure that their future is very bright no matter what. I'm going to share with you how to protect your assets if you become incapacitated or if you die, so that those assets are available for the benefit of your kids if they're still young, or to go directly to your kids if they're old enough to receive them directly. And then finally, we're going to talk about protecting your legacy. And when we get there, you'll realize how unusual that concept is. And in most estate planning, protecting your legacy is just not part of the conversation. It's not part of the plan. But at our firm, we think this is a super important piece. And I have built this piece into my own plan. I've received bits of legacy from other people, generations above me in my family. So I know, as a beneficiary of the legacy of others, how important that piece is. So we're going to talk about those four things: protecting yourself in the event of incapacity, protecting your minor children if something happens to you or to you and your spouse, protecting your assets, and protecting your legacy. Okay, so let's start with protecting yourself. This is how you create a plan for incapacity. If you get sick and you're in the hospital and you can't make decisions for yourself, who's going to be able to step in and make those decisions for you? Who's going to make your healthcare decisions? Who's going to make your financial decisions? Who's going to make any legal decisions that need to be made for you? Here's what you need to know. If you are single, there is no one who will automatically be able to do that for you. No one. They will all need court approval ultimately at some point and at some level. And even if you're married, your spouse does not automatically get to do all of these things for you. For in many circumstances, your spouse will need to get court approval to make legal decisions for you or to access financial accounts that may only be in your name if everything isn't held jointly. So it's really important for every adult, if you're 18 years of age or older, it's critical that you have a plan for incapacity. With a plan for incapacity, you will have named someone who will have the legal ability to step in and make decisions for you if you can't make those decisions for yourself. So what does that plan look like? Well, we're going to break it down into two buckets, okay? The first bucket is a medical decision-making bucket. And here in Massachusetts, there's 3 documents that you want to have in place in your medical decision-making bucket. The first is called a healthcare proxy. And this is the legal document in which you name someone else to step in and make healthcare decisions for you if you can't make those decisions for yourself. So if you're unconscious and in the hospital, a healthcare proxy will allow someone that you want to step in and make those medical decisions for you. If you're married, it may very well be your spouse. For most married couples, it would be your spouse. Not always, but most of the time it is. If you're single, you want to think about who you would trust above everyone else to make medical decisions for you. Now, if you've named a primary decision maker, you also want to name an alternate decision maker, just in case your primary decision maker is not available. So you want to have a primary and a backup decision maker for healthcare decisions. And again, you do that through what we call a healthcare proxy. Now you need a second document in your healthcare decision-making bucket, and that's called a HIPAA authorization or a HIPAA waiver. Because as many of us know or have discovered, there is a federal medical privacy law that's known as HIPAA. HIPAA stands for the Health Insurance, I'm not going to miss it today. The Health Insurance Privacy, I'm going to miss HIPAA tonight. I say this a million times a day. For some reason, I'm blanking on it right now. It is the law that protects the disclosure of your identifiable healthcare information to anyone but you. So in order for your healthcare decision makers to get access to your medical records, they need to be authorized through a HIPAA authorization. And so you want to create that in advance and make sure that your decision makers not only can make decisions for you, but they can access all of the medical records that they may need to make informed and intelligent decisions on your behalf. So that's the second document you need. Third document you need is called a living will. A living will is a roadmap that you leave for your decision makers about how you want them to make decisions around life-sustaining treatment. So if you're in a persistent vegetative state and somebody needs to make a decision whether to keep you alive artificially or to take you off life support, to keep you on or take you off life support, a living will is your way of leaving guidance to those people about what decision you would want them to make. Remember, you're unconscious, you can't speak, and so you want to leave that roadmap for them that will help them make a decision that can often be a very difficult decision. So again, those are the three documents in your healthcare decision-making bucket: a healthcare proxy, a HIPAA authorization, and a living will. Now, we've got a second bucket, which is our legal and financial decision-making bucket. And here there is one combined document that covers legal and financial decision-making. It's called a durable power of attorney, and very much like a healthcare proxy, it's your way of appointing someone else to step in and make legal decisions for you, to sign legal documents on your behalf, to access your financial accounts and to make financial decisions for you, to do things like reallocate the investment mix in your 401k or IRA, and even to do simpler things like go to the post office and pick up your certified mail and manage your social media accounts, your Facebook, your Instagram, your LinkedIn, your TikTok accounts. Basically to do all of the things that you normally would do for yourself on a day-to-day basis. But if you're incapacitated, you wouldn't be able to do those things. Well, now you've got somebody else who can step in and do those things. So that's the legal and the financial decision-making bucket. So all of that is part of a good, comprehensive incapacity plan. And if you're an adult, this is for you. If you're an 18-year-old, this is for you. We recommend that every 18-year-old have 3 of those incapacity documents in place: healthcare proxy, a HIPAA waiver, and a durable power of attorney. So if you've got a child who's 18 years of age or older, it's important for them to have these incapacity documents in place as well, because you, as a parent, once your child turns 18, will no longer be able to make decisions for your child and won't be able to access medical information about them in the same way you could when they were under 18, when they were still minors. And so if you've got an 18-year-old or an adult child, you have discovered along the way, sometimes to your chagrin and dismay, that all of a sudden on their 18th birthday, you can't do the same things you could do a week before. So every 18-year-old should have that plan in place. And Ruby, thank you so much. Sometimes my mind slips away from me and I can't latch onto the specifics. The Health Insurance Portability and Accountability Act. I've said it a million times. The Health Insurance Portability and Accountability Act, that's HIPAA, what we know as HIPAA. Thank you so much, Ruby. I appreciate that. Okay, so we talked about healthcare proxy, HIPAA, living will, durable power of attorney. Now let's shift and talk about protecting your minor children. So for those of you who have minor children, this is for you. If you don't have minor children, stick with me because we're going to get to some really important stuff in just a couple of minutes. If you've got minor kids, here's what I know you already know. What you already know is you need to name someone to step in and care for them, love them, raise them, guide them if you're no longer there. Now, those people are guardians for your kids. Most of you probably are familiar with the term guardian. What a lot of you don't know or have trouble deciding is who that's going to be, or how you go about deciding that, or how deep do I need to go, or and what are the things I need to be thinking about in choosing a guardian for my kids. Well, the number one thing you need to know before we even get to who's the guardian is that if you don't make a plan on your own for who's going to be the guardian of your kids, if you don't nominate guardians, someone else is going to decide this for you. And the someone else is a probate court judge. And if you're in Middlesex County, which is where our office is located, that probate court judge, Monday through Friday, is sitting in a courthouse in Woburn, and that judge is making decisions for families just like yours. Now, the problem with a judge making that decision all on their own is they don't know you, they don't know your kids, they don't know what's most important to you, they don't know who you would choose, and they don't know if there's someone you would never choose. Because some of you who are joining us tonight know that there are people in your families, even your immediate families, parents, siblings, that you don't want to be the guardians of your kids. And a probate court judge can't know that about you. So you want to make sure that you have named guardians for your kids. Here's something else you need to know. Traditional estate planning doesn't deal with a lot of your most pressing guardianship questions. And the reason why is that traditional estate planning is focused on clients in their 60s and 70s and 80s. And clients in their 60s and 70s and 80s, generally speaking, don't have young children that need protecting. But if you've got minor children, you do. So you want to be thinking about all the ways you need to protect your kids in naming guardians for them. Now, most of you have thought about this through one lens and one lens only. And that lens is what we would call long-term thinking or long-term guardians or permanent guardians. It's really the answer to the question, if I die, or if I'm married, if my spouse and I die, who do we want to take care of our kids until they're 18 and they no longer need a formal legal guardian? That's how most parents are thinking. That's the limit of traditional estate planning. They won't help you to think beyond that. Here's what I discovered as the parent of young kids myself, that there's much more to naming guardians than just that. Here's what else you need to know. Think about who you want your permanent guardians to be. Just if you've got young kids, take a moment right now. Think about the people who you would name as permanent guardians. Get a picture of them in your mind. You got it? Now, next, think about where they live. Think about how far that is from your house. For me, when my kids were young, that distance was 2.5 hours. We live in Middlesex County. My sister and my brother-in-law, who are the long-term guardians for my daughters, live on the Connecticut shoreline, 2.5 hours away. What happens if something happens to you? Your kids are at home by themselves, if they're teenagers maybe with a babysitter if they're younger, maybe with a caregiver. What happens if something happens to you and a police officer shows up on your doorstep? What happens if there's no clear plan for your kids and your guardians are hours of travel time away, like mine were? I'm going to tell you what's going to happen. What's going to happen is if there's no clear plan and your guardians are not immediately available to your kids, the police are going to feel compelled, knowing that something has happened to you, the police are going to feel compelled to call in the Department of Children and Families, and your kids are going to be removed from your home and placed in the hands of strangers until everything can be sorted out. Now, when I realized that years ago as a dad, that my daughters could be removed from my home and placed in the hands of strangers, I couldn't let that happen. My wife wouldn't let that happen. And what we both knew was that there were people who lived all around us, who we knew, who we trusted, who our kids knew, and who our kids trusted, who could come right over and be with our kids until my sister, my brother-in-law could get to my kids in our house. My neighbors who are only houses away, friends of ours in town who are only minutes away. All of those people would have gladly pitched in, helped, and taken care of my kids and covered that 2.5 hour gap until my sister, my brother-in-law could drive up from Connecticut. And so what I want you to be thinking about is not only who's going to take care of your kids if you die for the long term, but who's going to be able to step in and take care of your kids if there's a gap between the time something happens to you and the moment your long-term guardians can arrive and take over the care of your kids. Because maybe your family lives a couple of hours away. Maybe your family lives a flight away. And I've got clients whose families live days or even weeks away because their long-term guardians are outside of the United States. And if we've learned anything in the last year and a half, it's that your family outside of the United States can't always get into the United States to be with your kids immediately. They might not be able to get in at all, which makes making sure that you've got people close to where you live who can take care of your kids all the more important. So you want to think about long-term guardians for your kid. What happens if you die? What happens if you become incapacitated? You also want to think in the short term, what happens in that period of time before my long-term guardians can arrive and take over? And make sure you have included those short-term guardians in your legal plan. And by the way, if you've got long-term guardians outside of the country, or your family who you would name as guardians are outside of the country, you also want to make sure you've got temporary guardians named who can fill in not only a few hours, but who can fill in a period of time for a few weeks or even a few months until your long-term guardians can arrive if they're not going to be able to immediately get into the country. Take all of those pieces and put it together. In our office, that's our kids protection plan. Every single one of our clients who has minor children gets a kids protection plan as part of their comprehensive planning. No questions, no it's just built in. I wouldn't let anyone leave without it. That's how important that piece of your plan is. Okay, so we've talked about protecting yourself in the event of incapacity. We've talked about protecting your minor children. Let's talk about protecting your assets, because you all have assets. Some of you have more assets, some of you have less assets, some of you have liquid assets, some of you have real estate assets, some of you have Bitcoin or cryptocurrency. You all have assets. Here's what I can tell you. I'm just going to go back to one of the poll questions. Okay. Some of you have created a will or a trust. If you've only created a will, and for all of you who haven't created a will or a trust, who have no plan at all in place, here's what's going to happen to your assets if you die. Any assets that are owned in your own name are going to go by default into a probate, into a court process. And the court is the probate court. Some of you may have experience with probate court. Some of you may not. If you have experience with probate court, everything that I'm going to talk about next is going to sound painfully familiar. If you don't have any experience with probate court, let me share with you what your family's experience would be if you die without a good plan in place. Assets that are in your own name go through probate when you die. That process is designed to identify the assets you own at the time of your death, to get appraised values for those assets. The court appoints someone known as a personal representative, and their job is to figure out what assets you own, to get appraised values, to report everything back to the court. And the court's going to give your creditors a period of time to make claims against those assets. And depending upon the value of those assets, there may be an estate tax that's due 9 months after you die. But the probate process itself has drawbacks, the first of which is it takes a long time. In Massachusetts, probate takes at least a year. It can often take longer, but it's never shorter. So your family is going to be dealing with this court process for at least a year. It's cumbersome, which means your family doesn't have immediate access to your assets during this year-long process. If they need access because your kids need food or clothing or shelter or education, bills paid or healthcare bills paid, your family's going to need to get permission from the probate court, and that can take weeks or months, depending upon where in the process things stand. Probate is expensive. There's filing fees and publishing fees and accounting fees and legal fees and executor and trustee and bonding fees. And for most people, it's either thousands or tens of thousands of dollars that get chewed up in that probate court process. And that's money that doesn't go to your kids, that can't go to your kids. It's going to people you don't know to do things that aren't important to you. And let's be honest, won't make a material difference in your kids' lives. When your kids are young, they can't inherit assets directly if they're under the age of 18. So if you've got minor children, the court has to appoint someone to manage those resources for them, and it's very likely to be a stranger. Most likely the court, especially here in Massachusetts, is going to appoint someone from a list the court keeps of people who have experience managing money and who are bonded. And so it's very likely that a stranger will end up managing the money for the benefit of your kids. And that stranger is receiving a fee for providing that service. So that's part of the ongoing cost of probate. If you don't have a plan in place, no will, no plan, when your kids turn 18, by default, they're entitled to receive your assets. And that's whether or not you think 18 would be an appropriate age, or whether or not they would be financially mature enough to make wise decisions about what to do with those resources. They're just going to get it on their 18th birthday. And if you want to spend a moment right now and think back to when you were 18 and how you dealt with money and what would have happened differently in your life if somebody had pushed a pile of money across the table towards you, what I found in practice and what I found as a dad is that 18-year-olds aren't really financially mature enough yet to make wise decisions about what to do with that money. So it's just important to know, no plan, kids get it at 18. Now, you can make a different plan, but it's important to know that if you don't have a plan, that's what's going to happen. Here's the last thing about probate, and that's that it's very public. Everything that gets filed with a probate court is a public document. People can go into the probate court and look at everything that got filed, inventories of your assets, your wills, the names and addresses of your kids. People can look to see when your kids are about to inherit a substantial amount of assets. And you don't even have to go into the court in Massachusetts anymore. You can look this all up online. And for better or for worse, there are people who spend time looking through probate court records to see when an 18-year-old is about to inherit a substantial amount of assets. Excuse me. Now, having heard about probate, I suspect I know what you're thinking and feeling right now. Could be wrong, but I got a pretty good guess. The reason I have a good guess is I explained probate to a lot of people over a lot of years, and the response I get is almost universally the same. Is there a way to avoid probate? Can I get my family out of that court process if I die, because I want to make things as easy and as seamless for them? And the answer is yes, you can get your family out of probate. Your assets don't have to go through probate. Because again, it's a slow process with all of these drawbacks. The way you get out of probate is by creating a revocable living trust as part of your estate plan. A revocable living trust. If you're single, it's a trust you create for yourself while you're still living and for the people you care about after you die. If you're married and you create a joint trust, it's a trust that you create together and manage together for both of your benefit while you're still living, and then for the people you care about after you die. If you've got kids, obviously the people you care about are your kids. Now, you don't have to leave assets to your kids at age 18. If you create a revocable trust, you get to decide what happens to those assets. You can decide how and when you want your kids to get those assets. If you want to wait until they're 25 or 30 or even 50, you can write those instructions right into your trust. If you want to make sure the assets you leave to your kids are protected in their adult lives, so if they ever have creditor problems, or if they ever get sued, or if they get married and divorced, the money you leave them will be protected. You can build that all into your revocable trust. The best part about a revocable trust is that the assets in the trust don't go through probate. Assets in a trust on your death don't go through probate. So that's how you get out of the probate process. In the meantime, while you're living, the assets are still yours, essentially. You can use them. There's no limitations. There's no restrictions. And by the way, if you wanted to do a quick little exercise, you could do it after tonight about calculating your probate estate. Here's how you might do that. You would add up the following things: the equity value of your house, which is basically the fair market value minus your mortgage balance. That'll give you the equity value of your house. So add up the equity value in your house, your bank accounts, your taxable investment accounts, your retirement accounts, and if you have life insurance, you want to add in the face value of your life insurance policies. If you're married, take everything together as a couple, add it all together, come up with your number, and generally speaking, multiply it by 5%. And that will be the cost, the estimated cost of probate. The more assets you have, the more complicated probate gets, and the more expensive it gets. The younger your kids are, the longer someone else has to manage those resources for them, and the more expensive your probate estate and probate gets. And this will give you a rough estimate, not a hard and fast rule, but it will give you a ballpark figure. And if the number you come up with is a little scary, remember, a revocable trust is the way you get out of probate. Now, you've got to do more than just create this trust. You've got to create this trust, and then you've got to move your assets into the trust. You transfer your house into the trust, retitle your bank accounts in the name of the trust, your investment accounts. And on things like life insurance and retirement accounts, you would change the beneficiary designations so that they would be directed into your trust. And again, while you're still living, you still have control over all these assets, but those assets that are in the trust or are directed to go to the trust on your death, those don't have to go through probate. Your family is relieved of that court process. No year-long dealing with the court, no expense of it all. Your successor trustee would have near immediate access to your assets. The whole thing stays private. And again, you get to decide how and when your kids get those assets. Now, there's one more piece here, especially for those of you who are in Massachusetts, and that is there's a very low tax threshold for estate taxes in Massachusetts. Once you're over $1 million, and again, the equity, the life insurance proceeds counts towards figuring out the value of the value of your estate for tax purposes. If the total of your estate is over $1 million, there's going to be an estate tax in Massachusetts. If it's $1 million, the tax will be about $39,000. If you've got $1.5 million, the tax will be about $70,000. If you've got $2 million, it'll be $106,000. If you've got more than $2 million, it keeps going up from there. That tax is due 9 months after the date of the death of the survivor of you if you're married, or 9 months after your death if you are single. So that's an important piece. If you create a revocable trust, one of the second benefits of that trust, in addition to avoiding probate, is it gives you the ability to minimize or even eliminate that estate tax bill. So the trust is really the only efficient and reasonable way to do that. And then, as I mentioned earlier, one of the things you can do with a trust is you can set it up in such a way so that the money you leave to your kids is protected in their adult lives from creditors and lawsuits and a future divorcing spouse. So you can make your trust literally a vault for the benefit of your kids. So the money can only be available, is only available to them, can't be taken away from them by anyone else. And that is probably one of the reasons why, out of all the people I talk to, day in, day out, week in, week out, month in, month out, year in, year out, 95+% of the people I talk to who choose to do planning with our firm choose a trust-based planning option because they want to get their family out of that probate court process. They want to save on estate taxes, and they want to protect the money that they have left and are leaving to their kids. So that is how you protect your money. Last thing before we get into steps on how to get this into place, and that's protecting your legacy. And again, as I said earlier, this is a piece that doesn't show up in traditional estate planning. It's just not part of traditional estate planning. It's part of the planning that we do in our office, because I think this part of the planning is really, really important. And I've done it this way for 13, almost 14 years now. And legacy is all about intangibles. It's not your money. It's not your real estate. It's not the stuff that fills up your house. Your legacy is part of you. It's an intangible part of you. It's who you are. It's what's most important to you. It's all of the stories and memories and guidance and advice and lessons you would pass on and want to pass on to your kids, to the people who take care of your kids if you've got young kids, to the people who manage money for your kids. And even if your kids are adults like mine are now, you still want to pass on stories and memories and advice and guidance and lessons. That never ends. But here's the thing, all of those things that exist inside of you, all the things that you carry around in your head that you say, someday I'm going to share that with my kids, or I really want my kids to know that about me. If you don't share that with them in some meaningful way and something happens to you, it's gone forever, unless you've preserved it in some way, which is what legacy planning is all about. And it's so simple to preserve your legacy. It's so simple to preserve your memories and your stories and your lessons and everything you want to share with your kids and other people and maybe even the world. Because face it, right now, all of us probably have within arm's reach a recording device. We carry these recording devices around with us all day. So for some of us, it's the first thing we reach for in the morning, and it's the last thing we touch at night before we go to sleep. And the recording device is your phone. All of us have the ability to record on our phones, and yet none of us ever do, or most of us never do. So what we do with our clients in our firm is we set aside time and a space. It's a safe space where we can come together and we can get these lessons and memories and stories out in the open and recorded in an audio format that then our clients can pass on to their kids, to their guardians, to their trustees, to their families. And we do it that way because I know, as a parent myself, that if someone doesn't carve out that time for me, if someone doesn't give me a process, and if someone's not driving that process for me, I'll probably never do it myself. I walk around with the same iPhone in my pocket every day. I'm an estate planning attorney, and how often do you think I'm recording lessons for my kids? I don't, unless my wife and I carve out the time and very deliberately and intentionally take care of this. And I know for a lot of our clients who've got young kids and are running in a million different directions, they don't got the time or the bandwidth to think this through. And so what we do is we very deliberately, intentionally carve out the time for our clients so that we can build this piece of their plan while we're building the other pieces of their plan. So that's legacy. One other way to think about it, just think about somebody who's no longer in your life, who you would give anything to hear their voice again. That's legacy. And if you can leave a recording for the people who are important to you, they won't ever wonder at some future point in time, I wonder what it would be like to hear that person's voice again. Because we can just give it to them and then they'll have it. And they'll never need to wonder, I wish I knew that about mom or dad. You'll just tell them those things and then they'll know. So that's protecting your legacy, and not leaving anything unsaid. So those are the pieces of a plan that you create to protect you and your family through all stages of parenting. Whether you've got young kids or whether you've got adult kids, doesn't matter. If you got young kids today, someday you're going to have adult kids. I've got adult kids now. I used to have young kids. The planning is all about protecting you and your family through all of these stages of parenting. So let's talk about our kids' protection plan. And again, this is primarily focused on those of you with young kids, which I think is most of you on the call tonight. But a lot of the pieces here are going to apply to you even if you have adult kids. There's 9 steps. The first of those, and I think the most important of those, is to choose the right long-term guardians for your kids. But I also recognize if you've got young kids, this is very often the hardest piece. It's the hardest piece because sometimes the answer is not obvious to you, or you and your spouse don't agree on who it should be, or there are family issues or family stories that get in the way. So what I want you to know is that if you've struggled with naming guardians for your kids, number one, we have a process in our office called our 3-step process in which we help clients through that barrier to naming guardians for their kids. And no one ever has left our office without being able to name guardians for their kids. So if you've ever struggled with that, I just want you to know there's a way through that. Sometimes the way through it is to bring in somebody who can look at it objectively and help you to see it objectively, so you can make really good decisions. Step number 2 is to legally document your choice. It's not enough to think about who you want to be the long-term guardians for your kids. It's not even enough to talk about it with those people, although you should. You need to legally document your choice. If you haven't legally documented, then you haven't made a decision. So you do that through your wills. You do it in the event of incapacity through separate documents that cover incapacity. So there's, in our office, about 5 or 6, depending on situations, 5 or 6 different guardianship documents in total. So this, if you've got young kids, this is a big piece of the plan, but you've got to make sure it's documented legally or it's not going to be effective. You need to make sure there's guardians in the event you die, in the event you become incapacitated. So we want to make sure that part of the plan, no gaps at all. You do not want a leaky bucket of a plan around your kids. Step number 3 is to choose the right short-term guardians. Remember, we talked about if your long-term guardians are farther away, you want to make sure you've got people who are close by. Generally, we would say in about 15 or 20-minute travel radius around your house. So you want to think about who those people are and choose the people you think would be the best fit to take care of your kids on that short-term basis. And then step number 4 is to legally document that choice. Again, guardians are not guardians unless you've taken the precise steps to document it all legally. Step number 5, you want to give your short-term legal guardians documentation and instructions on what they should be doing if their phone rings at 11 o'clock at night on a Saturday night and your babysitter's on the other end and you haven't come home. So you want to give them a copy of the document that gives them the authority to step in, and you want to give them some level of instruction about what to do, again, if the phone rings at night. You also want to give your caregivers, babysitters, nannies, caregivers, schools, instructions on who to call and what to do in an emergency. So what we do for our clients is we create 2 sets of ancillary documents beyond the legal documents. The first is what we call caregiver instructions or babysitter instructions. Very, very simple. Sheet of paper with your cell phone number or numbers, if you're married, on it, the names and the telephone numbers of everybody you've given short-term legal authority to. So now a babysitter would know who to call in an emergency if you don't show up or if you don't answer your cell phone. What we do then is we laminate right on the backside a copy of the legal document. So as long as a babysitter knows who to call, they've already got a copy of the legal document in their hands in case there's a police officer who shows up on your front step. Then no one is trying to find a legal document in a moment of chaos or crisis. The other thing that we create for our clients is what we call a family emergency ID card. A laminated card that fits in your purse or wallet that's got the names and the telephone numbers of your short-term guardians, including your spouse if you're married. And if you're carrying that in your purse or wallet, you get into an accident, somebody will find it. They will know that you have young kids, and they can be calling the people who have the authority and instructions regarding the care of your kids. When my kids were young, this was in my wallet right behind my license. And even after my youngest daughter turned 18, I still carried that card till about a year ago. She's 21 now. I literally carried it to just about a year ago. And now it's on my desk in my office. And I can share it on Zoom calls with prospective clients. So that's step number 6. Step number 7 is to make sure your long-term guardians, your permanent guardians, have instructions about how you want them to raise your kids. Now, there's a bunch of different ways you can do this. You can write letters to them. Our legacy interview that I talked about just a few minutes ago, a few of those questions are directed to guardians about how you want guardians to raise your kids, what's important to you, what religion are you raising your kids in, what's important to you, what experiences do you want your kids have. Help your guardians to raise your kids as close to the way that you would if you were still there. And let's not just assume that our sister or our brother or our sister-in-law or our brother-in-law or our parents or our really good friends just instinctively know how we would do that. Let's give them the gift of guidance. So let's make sure they've got instructions, and as importantly, make sure they've got copies of your guardianship documents that name them, and make sure they know where to find your estate planning binder. You want to let them know where it is and how to get their hands on those documents if something happens to you. Step number 8, again, around guardianship. For those of you who have people in your family that you know you don't want to be the guardian of your kids, maybe you don't want your parents to be your guardians. Maybe you don't want a sibling or some of your siblings to be the guardians. There is a way to exclude people from guardianship. So if that's important to you, just know that you don't have to worry about somebody challenging your decisions, that you can confidentially exclude individuals and multiple people from being allowed to be named as guardians of your kids. By the way, this was part of my plan for a really long time when my kids were young. So I totally get this, and I work through this with a lot of our clients. It happens more often than you would think. And finally, step 9 is to make sure that you have left financial stability behind if you die, so that your kids are never wanting for the things you would have otherwise provided to them. Make sure that you've got this in a trust, so all of it will be immediately available for the benefit of your kids, and the whole thing will stay private, and your kids won't get their hands on the money until they're ready. Not that it won't be at all, or it won't be for so long into the future, but let's get the money into their hands when they're ready and under the circumstances that will make the most sense for them and will protect them the most. And again, as we talked about earlier, a trust is really the way to do that. So those are the 9 steps. Now you've got a roadmap for getting this planning in place. So what can you do right now to move this ball forward? If you came here for an education, you've gotten it. If you came here for some next steps about how can I finally get this in place? Very interestingly, I was talking to some clients this week who've been meaning to get their planning done, and they put it on their to-do list every January. And they were telling me that for the last 5 years, every January, okay, it's January, we didn't get this done the year before, now is the time we need to get it done. Every year for 5 years. And then last November, I did a webinar for a family network. They were part of that family network. They heard me speak on this, and I gave them a next step, and they took it. And after beating themselves up for 5 years, we've got to get this done. We didn't get this done. Now we got to get this done. We still didn't get this done. All I had to do was give them just a little step that they could step up on and then they could see the next step ahead of them in a way they couldn't before. So I want to give that to you tonight. Give you a little step up so you know how you can get started on this for your family, so you don't have to lay awake at 3 o'clock in the morning staring at the ceiling, wondering what's going to happen to your kids if something happens to you. Let's get this planning in place for you once and for all. Let's get this off your plate, and let's give you the peace of mind of knowing that this planning is finally in place to protect your kids and your family. So what I want to offer to you is some time on our calendar to talk to me or one of the other attorneys in our office. We offer a consult that we usually set aside 2 hours for. The first hour is helping you get really, really clear about where you are, where you want to be, and we'll talk about mechanically how you would get there. And then the second half of that 2 hour meeting is if you decide, yes, I want to get my planning done. Yes, David, you and your team are the right fit for me. And we have determined that you're a good fit for us as well. And you want to move forward with your planning, then we would use the second half of that 2 hour meeting for getting your plan designed. We do all of these meetings through Zoom. You do not have to leave your house. You don't necessarily have to find babysitters for your kids. You can sit in your living room, your family room, your home office, your kitchen. Doesn't matter. We're going to do it on Zoom. You don't have to go out into the cold. You don't have to go out into the dark. We're going to make this as easy as possible for you. Now, in order to get a consult like that scheduled, your next step would be to schedule a time to talk with our client services coordinator. Her name is Lori. There's Lori right there. Lori is an awesome human being. Lori's been with our firm for about 4 years. She's terrific. Prospects love talking with her. Clients love talking with her. Those of us in the office love talking with Lori. So there is on the left-hand side of your screen, in the lower left-hand corner, there is a link to click to book a call with Lori. What you'll do is you'll go to Lori's call calendar, and you can schedule a time that's convenient for you that Lori's got open to have an initial intake call with Lori. Lori will get to know a little bit about you. Lori will tell you a little bit about our firm, how we work, and how an initial consult, how it will look and feel for you and what you can expect in an initial consult. And if it seems like a consult is the right move for you, and I strongly recommend to you that it should be, then Lori can get you scheduled for that consult. But your first step is to book a call with Lori. All you've got to do is click on that link, click to book a call. You'll go right into Lori's calendar and pick a time that is convenient for you. Lori should have lots of times available to choose from over the next week or two. The last thing I wanted to share with you is I wanted to share, and I think it's already in the handout section, there is a kids protection planning guide. And if you haven't already had a chance to download that, you can go ahead and download that. And then you'll have that to refer back to. It talks about and summarizes a lot of the same things that we talked about tonight. So, we're going to send you a replay of this recording so you can go back and listen again if you need or want to. But downloading the Kids Protection Planning Guide will also give you a hard copy, as it were, resource that you can look back and read at your leisure. So again, click to book a call with Lori if you want to explore an initial consult with us in our office to talk about your particular situation. What I want to do now is I want to go back through the chat and see what questions have popped up for you. And if you haven't posted a question yet, and you still have some questions or a question that you want to get answered, you can drop them into the chat. And so let me head down this list. All right, so somebody says, I have a will that spells out everything for my assets and guardianship for my kids. However, I did get married in 2019. Do I need to update my will, even though it says my current will, says in my current will that my house and my assets go to my kids, and those are my wishes? Would mass law honor this will, or would everything automatically go to my husband? You do want to review your will and update your will. Because in Massachusetts, your spouse, if not named in your will, has an automatic right to a portion of your estate, despite what your will says. So now that you're married, it's been a couple of years, it would probably be very, very beneficial for you to schedule a call with our office, or if we're not a good fit for you, with another estate planning attorney. But I'd be happy to talk with you about this, about what your estate plan could look like, should look like now that you're remarried, and how you can set things up so that each of your sets of kids, if you're both coming to your marriage with kids from a prior marriage, can be protected, but still, taking care of each other at some level, if that's important. So yes, I would have your plan reviewed and get some good advice about how you can bring that plan up to date and figure out what, if any, pieces of that may be missing. A question came in: what is the average cost for estate planning? That's a really hard one to answer, because there is no average cost. What I can tell you is that our estate planning can be as high as $12,000, but it could be as low as $3,500 if you're married, or a little bit less if you're single, and it can be anywhere in between. That is for a good, comprehensive, no gaps in it estate plan. And everybody's different, everybody's needs are different, and so we give clients the option of choosing the planning level that's right for them. So we've got 4 different planning levels. Clients get to choose the planning level that's right for them. It's not my job to tell you what you need. It's my job to share information with you, give you the tools to make decisions for yourself. Estate planning, for most people, you do it, you create the foundational plan, and the value you get from that plan, or more importantly, the value your family gets from that plan, is so far in excess of the dollars you pay to put it in place that it's exponential. Let's put it that way. You can spend a few $1,000s on an estate plan and save your family tens and hundreds of thousands of dollars. So there's more of your hard-earned resources that will be available for your family, instead of going to a stranger in probate or going to the taxing authorities, if you've got an estate tax. A way to think about it, just to give it some context. My office is in Acton. There is a swing set store in Acton called Creative Playthings. And I see their swing sets all over the place. Backyards in Acton and Boxborough and Littleton and all the towns around our office as I'm cruising around. And I remember what it cost to buy a swing set. I think it was a Child Life swing set, one of those green swing sets when my kids were young, but it was a very simple swing set. But I remember it was like a couple $1,000. No slide, no tower, trapeze bar, a swing. So I was talking to a client about 6 or 7 months ago. We were talking about the cost of estate planning. We were talking about getting a plan in place for him, his wife, and his kids. And he said something very interesting to me, and it stuck with me. And I pray it will probably stick with me forever as I talk about estate planning. He said, I think it's only right that I spend at least as much on an estate plan to protect my kids as I spent on the swing set that I bought for them that's in our backyard. So for those of you with minor kids, think about how much you spend on a swing set that you stick in the backyard, the ones with the slides and the towers and the monkey bars and all of that. And when we got to the end of the planning for this client, I basically said, how'd we do? And he said, pretty much right on. This estate plan is costing pretty much almost exactly what I spent on the swing set that's in the backyard that my kids play on. So is it worth the cost of a swing set to protect your family for years and years into the future? Is it worth the cost of a Disney vacation that you may only take once? Just think about it that way. Don't try to go cheap on an estate plan. Cheap estate plans are estate plans that have big holes in them. And the problem is nobody discovers the hole until it's too late after you die. All right, that was it for questions. That wasn't very many, which is usually a sign that I did a pretty good job in laying out the information. So if you haven't had a chance to click on that link to book a call with Lori, do that right now. Don't put it off. Don't say, I'll come back to this later. Just at least click on the link, get that page open, even if you want to go and check your calendar or check with your spouse. But get in there, book a call with Lori, spend 10, 15 minutes on the phone with her, let her help you figure out if this is all right for you and if we're a good fit for you. And even if we're not the right fit for you, Lori can probably connect you with somebody who can help you if it turns out that we can't or we're just not the right fit. So take advantage of the opportunity to do this. Take that next step. Move this ball forward. Don't let everything you've learned tonight kind of fall away, because as soon as you go to bed tonight, you wake up tomorrow, everything will be, you've got a new day. Things are going to pop up, and I don't lose the momentum that you gathered here tonight. I want you to take advantage of that momentum. All right, everybody. I had a great time with you tonight. I hope you did as well. I hope you learned a lot. I'm going to close out the room right now, but I don't, before I go, I just wanted to say thank you so much for sharing your time tonight. Thank you for sharing of yourselves tonight, asking great questions. I have enjoyed sharing all of this with you, and I certainly hope that we have the opportunity to talk face-to-face or at least over a Zoom call really soon, and I hope we have the opportunity to help you protect your kids and your family. Thanks, everybody. It was great to talk to you tonight, and we'll talk again real soon. Take care.